Hello and welcome to Ask Amanda Now. I am coming to you today from the sunny, yes it is sunny, west coast of Ireland. And as they say here, Agus Fulcha. There's a little bit of Gaelic there for you. My Gaelic is tiny bit better than my Spanish. If you've been tuning in over the last couple of weeks, I've been traveling through some parts of Europe with my family. We've been in Spain and we are now in Ireland. And if you saw the post here on the page earlier today, you'll know that Ireland is my dad's birthplace. I've got lots of family, lots of cousins here. We are here in Connemara. Some of you may have visited this beautiful part of the world previously. And yes, my dad does speak Gaelic. So I've just dropped in actually to his B&B to be able to get the better Wi-Fi. And I called up the stairs, Dad, how do you say hello and welcome in Gaelic? So Agus Fulcha to you. That's what I've learned for today. How are you all today? How has your week been in Strata? Today is our opportunity to have a closer look at one particular Strata question. We do have one in the wings for you. I'll be here for about 10 or 15 minutes or so before I head out into the day. It is the morning here in Ireland. I appreciate that it's probably Friday afternoon, evening where you are. I can see my team in the background very eager to get this question out. So Mina, go on ahead and bring that question up on the screen. Today's question does come from Elizabeth, and I know that Elizabeth tunes in regularly. So if you are here live, Elizabeth, please do give us a hello. You're the one. You're the one who has been chosen today. Lucky you. Elizabeth's question was here on the page. This is just a summary that you're seeing on the screen here. Say the committee breached the Act. Then what? What do we do if we have a Strata committee breaching the Strata legislation? Now, Elizabeth's longer version of this question, you can have a look at it here on the page. But in answering this question, Elizabeth has also let us know a few of the things that she's already doing to deal with these breaches, she says, of the Act that her committee is doing. Elizabeth says, do I raise it at the meeting, even though it's not on the agenda? Do I put it on the agenda for the next meeting? Do I put that on a committee meeting agenda or a general meeting agenda? These meetings might be months away. It sounds like Elizabeth is already taking those steps, and she's saying in her post that most of the time, it doesn't matter if I put these issues on the agenda. It makes no difference to the outcome. I keep putting forward motions, identifying these breaches. I'm asking the Owners Corporation to confirm that the committee is not acting in the best interests of all owners. But in Elizabeth's building, there is apparently a majority owner, someone who holds the power of the vote, who is simply calling a poll and voting against everything that Elizabeth is putting forward on the agenda. So she says in her post, the breaches are on the record, but nothing is being done to rectify those breaches. So what is it that she can do, and how can we help Elizabeth today? So great question. I know it's a big question, and it really goes to the heart of what we do here. How do we, by using the legal tools that are available to us, improve our communities by ensuring that there's compliance with those legal rules and that everything is running smoothly and hopefully more peacefully for those of us who are living in and investing in Strata. So thank you for asking this one, Elizabeth. I can see a few eyes coming in with us live today. I am here on the sunny, as I've said, a couple of days we've had rain, a couple of days we've had sun. Today we're lucky to have a sunny day here on the west coast of Ireland. You can see those very famous stone walls there behind me, and you would have seen quite a magnificent, I thought, scenery in that photo that I've posted here on our Facebook page. You'll see it over on Instagram as well from a couple of days ago. Just checking in on the team's comments there. Everything seems to be coming through loud and clear, which is great. All right, so getting into Elizabeth's question, the committee's breaching the Act. What is it that we can do? Now, when I approach these questions for clients of my legal practice, for members in our forum, I tend to say there's five steps that you can be taking, or think of this as a five-step process or a five-part framework. So I'm going to speak generally because we don't really know, and Elizabeth hasn't shared, which is fair enough, what exactly these breaches are. Some are more serious than others in certain communities. So we might have communities where there's no insurance being entered into, for example. That's a pretty serious breach of the Act. Communities where levies are not being paid, where common property is not being repaired. In other communities, breaches might be a little less serious. Maybe there aren't regular committee meetings. Maybe when there are meetings, notice periods aren't complied with. Maybe there are some procedural issues that are going on, which we may say, when compared to those other more serious breaches, are probably a little less serious. So I'm not going to get into different types of breaches, but I am going to speak generally. If your committee is not performing, is not complying with the Act, then what things can you do? So first of all, and I think Elizabeth is doing this, writing to the committee either directly or via the Strata manager to let them know what it is that you're not happy about, what it is that you think they're doing wrong. If Strata committee meetings are not being held, explaining that that should be happening. That is a way that a community is most transparent. Make sure that its owners know what's going on, what decisions are being made. If there isn't a minuted resolution for a decision of the Strata committee, then be asking, when was that decision made? At what meeting? Can I please see the minutes of that meeting? So writing to the committee, if you have a Strata manager, then you'll be writing care of the Strata manager. I'm talking about sending emails here. Getting these concerns on record is really the first step that should be taken. And I can see from Elizabeth's post that that's something that she is and has already been doing. Secondly, proposing motions for meeting agendas. So that is the way that you draw these concerns to the attention of other owners. So when you're just writing to the committee, you're just writing to the Strata manager, then you're kind of in this closed communication loop. Other owners are not necessarily aware of your concerns, what's going on, what these breaches of the Act might be. But the minute you propose a motion for a general meeting agenda, then you're bringing these issues to the attention of other owners. In New South Wales, if an owner proposes a motion for the agenda of a general meeting, then the secretary must put that motion on the agenda of the next general meeting. That is a mandatory legal requirement in New South Wales. Elizabeth's asked the question, as part of her question, she asked, should I be proposing these motions for Strata committee meetings or proposing them for general meetings? Here's the thing, owners in New South Wales are not actually allowed. There's no provision for owners to submit motions to Strata committee meetings, interestingly. Your right to submit, or requisition we might call it, a motion is limited to general meetings. Having said that, you can ask your secretary, your committee, your Strata manager, can you please consider this issue at your next Strata committee meeting? But it is open to the committee to say, nope, we don't have to. You're not a committee member, you're not the secretary. You as an owner have no say in what goes on the agenda of a Strata committee meeting. Not the case for general meetings. So if you're proposing motions to cure problems, to ask questions about problems, to be suggesting that certain steps or asking that certain steps be taken to ensure compliance with the Act, you want to be doing that through a motion submitted to the general meeting. Now, I think Elizabeth is saying that she has been doing this, and I know Elizabeth has been in our community for quite some time now, so she's a pretty savvy player and understands a lot of these steps, I know. She's proposing these motions and she's saying nothing's changing. No, there is no acceptable, suitable outcome or resolution of these concerns because there is a majority owner in the building who just votes everything down. So even though I'm proposing motions that owners recognise, that owners acknowledge, that owners censure perhaps the actions of the committee, those motions are simply being defeated by the majority owner. So what next? Well, in my 5-step framework that I'm talking about today, next, number 3, is to lobby for a new committee if you can. At every AGM, a new committee is elected. So we vacate all positions of the Strata committee, new committee is elected. Is there a way to encourage other owners to put their hands up, to be on the committee, and therefore to effect change by essentially a change of regime, changing of the guard? Can we get some people with different interests who are perhaps more community minded, who are perhaps more aware of their obligations? Can we get those kinds of people elected to the committee so that when decisions are being made at committee level, they are the right legal decisions? Can we have a spill of the committee and get some new people elected? I know, easier said than done. Easier said than done in many communities, but it's definitely a step that is important to take, to attempt, to contemplate. I'm just having a look here in the comments. Hey, Leonie, who is here. Can't you ask as a special request? Not quite sure what you mean there, Leonie. So you can put forward a motion for a general meeting. You can, in New South Wales, issue a qualified request. That might be what you're thinking of, a qualified request forcing a general meeting. You do need 25% at least of the unit entitlement to be able to successfully put forward a qualified request. But as for requesting a committee meeting, if you're not a committee member, as for proposing motions for a committee meeting, if you're not a committee member, there's no provision in our legislation for that. It's only at the general meeting level that owners can put forward motions or force general meetings to happen. Emiliana, hey, lovely to see you, saying hello from down under. Happy to know that you're enjoying Ireland. How nice to have a huge family. It does feel huge sometimes, not as huge as some of these families that we're related to here in Ireland. Emiliana says she's one of 100 relatives. I haven't met, suddenly turning into a reunion. Excellent. So good to hear, Emiliana. Leonie saying, yes, she is talking about a qualified request. Yep. So that's the way that you can, if you've got a small group of owners with at least 25% of the total unit entitlement, you can submit a qualified request, and then the secretary receiving that qualified request must convene a general meeting within 10 days. Maybe it's 14. I'll come back around and post that link, section 19 in our Strata Schemes Management Act. Within a specified time that's there in section 19, a general meeting must be convened upon receipt of a qualified request. It's actually one of our more popular templates inside our members library. I've got a template form for those members who are wanting to submit a qualified request, template covering letter, the kinds of words that you should be using to ensure your compliance with the Act. Thank you, Leonie, telling me that, yes, 14 days. The secretary receives a qualified request, must then convene the general meeting within 14 days. Excellent. Okay, so committees in breach of the Act, what do I do? I've told you there are 5 things that you could be doing, a 5-step process that you can follow. Write to the committee, care of the strata manager if you have one, letting them know, creating that paper trail, putting these things on record. Secondly, proposing motions. Generally, we're proposing motions for our general meetings, not our strata committee meetings. You can try propose a motion for a strata committee meeting, but as an owner, it's the general meeting to which you are entitled to propose motions. Thirdly, lobby for a new committee members to be elected at the next AGM. Fourthly, and this is where I have seen some owners have success in the past, and it starts with a question: is it possible that if you do have a professional strata manager in place, that the manager might be part of the problem? I see this in some communities where the committee is just not getting good advice or the correct advice from the strata manager, or the strata manager is not telling them what the requirements of the Act are. So they don't know, as committee members, that they are in breach. They don't know what they should be doing. So is the strata manager doing their job correctly? And if they're not, then is it possible to lobby for a change of strata manager? So, I'm seeing Elizabeth here. Hey, Elizabeth, how are you? Good to see you. Elizabeth just said, yep. So I'm wondering if you're saying yes to this 4th point here. Do we need to change strata managers or look for better management, someone who can more properly, more appropriately, more professionally, perhaps be guiding the committee. So Elizabeth's saying the strata manager works for the committee, so that's part of the issue in her community. I'm seeing Leonie say yes as well. All right, so this one has hit a nerve, and I see this. I see this in my legal practice. I see when I have member calls with the members inside our online community, that when we get to the heart of the issue, there seems to be a breakdown in this role of the strata manager, and there is a problem with the advice that the committee is getting, or the fact that the committee is just not getting any advice about what it should be doing, and that's really at the heart of the problem. And then I see communities that are able to, at the end of their strata manager's contract, appoint a new strata manager and they say to me, Amanda, it's such a relief. I didn't realize how different it would be, how much easier it would be that when we've now got somebody in place who knows what they're doing, who's properly guiding the committee, who's calling them to account, who's pointing out to them the requirements of the legislation. So that is the fourth part of my 5-step framework here. What do we do if our committee, if our owners corporation is breaching the Act? Have a look at that role of the strata manager. How do we change strata managers? Well, a new manager does have to be appointed at a general meeting. And of course, we want to make sure that we're not breaching the contract of the current strata manager. They may have a term of appointment that could be 1 year, could be 2 years, could be 3 years. We have 3-year maximum terms in New South Wales. So if you're thinking about changing strata managers or lobbying other owners for a change of strata manager, the first thing you want to look at is, when does their term of appointment end? So are they coming up for renewal next year? Is it next month? Is it in 2 years' time? And then being able to work towards that date in your planning, talking to other strata managers who may be able to better serve you, getting support for the appointment of that person when the time is right. Time goes fast, so getting prepared for that kind of change as early as possible is a really good idea. Elizabeth's saying the majority owner chooses the strata manager that is compliant with his wishes, and so we always have problems. Yeah, and I know the situation you're in, Elizabeth. It's so hard to achieve success with these steps when you don't have support from other owners. So when it's just you and maybe a handful of others, and then you've got a majority owner who just votes everything down, I acknowledge, I understand completely that it's going to be very hard for you to get anywhere with these, let's call them the non-litigious steps, but they're still important. They're still important to take, because you might have guessed it, the 5th step in my 5-part framework for dealing with this issue is litigation. It's going to the tribunal. It's saying to the tribunal, we are not functioning satisfactorily. The management of our owners corporation, whether it's via the strata manager, whether it's via the strata committee, one of those or both of those management structures is not functioning satisfactorily, and therefore we need a compulsory manager appointed, an administrator taking on all powers of the owners corporation for a certain period of time. That's the last resort. I always say litigation should be your last resort, and in a community where you just can't get anything sensible, reasonable, legal across the line, that may be where you're heading. But if you've taken all of these steps prior to commencing that litigation, what you're going to have is this beautiful paper trail, this beautiful record of having asked and been refused, of having put the committee, the owners corporation, the strata manager on notice of their breaches of the law, having had those ignored. And that's all going to give weight to your argument that this owners corporation, this strata committee, this strata manager is functioning in a way that is unsatisfactory, and ground your application for the compulsory appointment of a strata manager. Now, I said right at the beginning of this chat that these suggestions are all very general, and I don't know the kinds of breaches that are happening in Elizabeth's community, and much does depend on how serious those breaches are. If there are errors in procedure when it comes to meeting dates and times and the way that a meeting runs, generally speaking, the tribunal's not going to interfere with that by appointing a compulsory strata manager. But in a building where common property is not being properly repaired and maintained, where levies are not being raised, where the insurance is not being paid, those are the situations, and often all of those things combined, that the tribunal is going to pay attention to and say, we've got one owner here who has tried, I can see, to get all of this across the line. It's not happening. The way to solve this is to appoint a compulsory strata manager. So that's the 5th action step in my 5-step plan here for you, Elizabeth, and that could be where you are ending up. Elizabeth saying here, it is more procedural. Yeah, that's frustrating. It is frustrating. Leonie's, I think, agreeing, saying compulsory last resort. Yes, we've heard here on the page, we've talked about it on the podcast. Many owners have very poor experiences of compulsory management. It can be a risky path to go down, so you do want to be careful if you're heading down that way. Okay, Shana saying, hi Amanda, a bit colder this week in Ireland compared to Spain. Yes, yeah, got my woolies on here. I've got my scarf here next to me and my jacket. I said earlier that I've just popped up. My family and I are staying at a B&B just up the hill, and I've just popped down to my parents' B&B to steal their Wi-Fi. And yes, all rugged up. It's early in the morning here, and we are looking forward to another day out. We're actually heading over to the Aran Islands today, one of the Aran Islands. If anyone's been over to the islands, do let me know. It'll be a first time for me. And well, looks like we've got a great day for it to head out there, which is exciting. All right, so that's Elizabeth's question. That is my answer. Detailed. I'm going to say detailed. We're 20 minutes in here, a little more detailed than we usually go on an Ask Amanda Now. My detailed answer to Elizabeth's question, 5 steps there that you can take to deal with, attempt to do your best to deal with a strata committee's breaches of the Act. If you've just popped in, and I can see a number of eyes there that have popped in just within the last few minutes, do go ahead and watch this replay so you get all 5 of those steps. It's been great to spend this morning with you. I'm going to go finish my cup of tea. I'm going to wish you a lovely Friday evening, no doubt, where you are, and I will look forward to catching you all here next time. Thank you for joining me. Thanks for your question, Elizabeth. Have a great weekend. Bye for now.